The nature of law and human rights law. The nature of law and human rights law explores the nature of law within a broader social context, examining how law relates to morality, justice, and society, as well as considering its evolving character. It brings together knowledge of the English legal system, legal rules and principles, and key concepts and issues from across the course. The exam also focuses on the principles of human rights law, including how rights are protected, interpreted, and applied within both domestic and international contexts. Introduction to the nature of law. The nature of law is a system of rules and principles created and enforced by the state to regulate behavior and maintain social order. Law and rules. The law is a formal mechanism of social control that sets standards of conduct and provides consequences for those who breach them. Whereas rules are guidelines or expectations that govern behavior in society, they are not always legally binding or enforced by the state. The difference between legal rules and principles and other rules and norms of behavior are that legal rules are enforceable by courts and sanctions, where other norms rely on social approval or moral pressure. Law, morality, and justice. There are many connections between law, morality, and justice. The connection between law and morality is that law is often influenced by moral values, although it does not always reflect what society considers morally right. The connection between law and justice is that the law aims to achieve justice by providing fairness, consistency, and protection of rights, although it may sometimes fall short. The connection between morality and justice is that moral principles shape ideas of what is fair and right, where justice seeks to apply those principles equally within society. Civil and criminal law. Civil and criminal law is the two main branches of law, where civil law deals with disputes between individuals and criminal law deals with offenses against the state. Civil law. Civil law is the area of law that resolves disputes between individuals or organizations, usually over rights, obligations, or compensation. The procedures in civil law are based on one party bringing a claim against another, using standards such as the balance of probabilities. The purposes of civil law are to resolve disputes, enforce rights, and provide remedies where harm has occurred. The outcomes of civil law are remedies such as damages, injunctions, or specific performance rather than punishment. The court systems of civil law are mainly the county court, the high court, and appellate court such as the Court of Appeal and Supreme Court. Criminal law. Criminal law is the area of law that deals with conduct considered harmful to society and prosecuted by the state. The procedures in criminal law are based on the prosecution proving the defendant's guilt beyond reasonable doubt. The purposes of criminal law are to punish wrongdoing, deter crime, protect the public, and maintain social order. The outcomes of criminal law are sanctions such as imprisonment, fines, community orders, or acquittal. The court systems of criminal law are the Magistrates' Court, the Crown Court, and appellate court such as the Court of Appeal and Supreme Court. Differences between civil and criminal law. The differences between civil and criminal law are that civil law focuses on private disputes and compensation, where criminal law focuses on public wrongdoing and punishment. The differences between the procedures in civil and criminal law are that civil cases are brought by individuals using the balance of probabilities, where criminal cases are brought by the state using beyond reasonable doubt. The differences between the purposes of civil and criminal law are that civil law aims to resolve disputes and compensate loss, where criminal law aims to punish and deter offending. The differences between the outcomes of civil and criminal law are that civil law results in remedies, where criminal law results in penalties or acquittal. The differences between the court systems of civil and criminal law are that civil cases are heard mainly in the county court and high court, where criminal cases are heard in the magistrates' court and crown court. The development of English law. English law has been developed through custom law, common law, and statute law. Custom law. Custom law is law that arises from long-established practices that are accepted as legally binding by society. Custom law has been developed through repeated behavior over time that is regarded as reasonable, certain, and continuous. In the early stage of development, custom law emerged from local practices that communities consistently followed as obligatory rules of behavior. In the later stage of development, customs were recognized by courts once they were proven to be long-standing, reasonable, and accepted by the community. Custom law is applied by the courts where they recognize a custom as legally binding and enforce it as part of the law. This is shown in the case of New Haven Port and Properties Limited v East Sussex County Council. Common law. Common law is law created by judges through decisions made in court cases rather than by Parliament. Common law has been developed through judicial precedent, where decisions in earlier cases guide the outcomes of later similar cases. In the first stage of development, judges decide cases based on reasoning and fairness where no statute applies. In the second stage of development, those decisions are recorded and become binding or persuasive precedents for future cases. Common law is applied by judges who follow the doctrine of precedent when deciding cases. This is shown in the case of Robinson v Chief Constable of West Yorkshire Police. Statute law. Statute law is law created by Parliament through Acts of Parliament. Statute law has been developed through the legislative process, where proposed laws are debated and approved by Parliament. In the first stage of development, a bill is introduced and examined in both Houses of Parliament. In the second stage of development, the bill receives royal assent and becomes an Act of Parliament. Statute law is applied by the courts, which interpret and enforce legislation passed by Parliament. This is shown in the case of Miller v Prime Minister. The rule of law. The rule of law is the principle that everyone, including the state, is subject to and accountable under the law. Importance of the rule of law. The rule of law is important for achieving justice as it ensures fairness and consistency in how laws are applied and enforced. However, it may not be important as strict application of the law can sometimes lead to outcomes that seem unfair in individual cases. The rule of law is important for human rights as it limits arbitrary use of power and protects individuals from abuse by the state. However, it may not be important as governments can still restrict rights through laws that are formally valid but morally questionable. The rule of law is a guiding principle of law as it underpins legal certainty, accountability, and equality before the law. However, it may not be as effective where those in power are able to influence or bypass legal processes. Elements of the rule of law. The core elements of the rule of law are equality before the law, legal certainty, and access to justice. Equality before the law means that all individuals and authorities are subject to the same laws regardless of status or power. Equality before the law is a guiding principle of law as it prevents arbitrary discrimination and ensures fairness in legal decision-making. Legal certainty means that laws are clear, publicized, and applied consistently so people can understand their legal rights and duties. Legal certainty is a guiding principle of law as it allows individuals to plan their actions and trust the legal system. Access to justice means that individuals are able to enforce their rights through fair and impartial courts. Access to justice is a guiding principle of law as it ensures that legal rights are meaningful rather than theoretical. Evaluation of the rule of law. The benefits of the rule of law are protection from arbitrary power, fairness and equality, and legal certainty. Protection from arbitrary power is a benefit as it restricts government action, shown in Miller v Prime Minister. Fairness and equality are benefits as the law applies equally to all, shown in R v Joji. Legal certainty is a benefit as it provides clarity and predictability, shown in Unison v Lord Chancellor. However, the drawbacks of the rule of law are rigidity, potential injustice in individual cases, and limited protection against unjust laws. Rigidity is a drawback as strict adherence to rules can ignore individual circumstances, shown in R v BE. Potential injustice in individual cases is a drawback as equal treatment can still produce unfair outcomes, shown in R v Hallam. Limited protection against unjust laws is a drawback as laws can be valid yet unfair, shown in R v Secretary of State for the Home Department. Law and morality. Laws are formal rules created and enforced by the state to regulate behavior and maintain order within society. Whereas morality is a set of personal and societal beliefs about right and wrong that guide individual behavior without formal enforcement. Laws and morals. The functions of law are to maintain social order, protect rights, resolve disputes, and provide predictable standards of behavior. The functions of morals are to guide individual conscience, shape social values, and influence behavior through social approval or disapproval. Law and morality overlap as many laws reflect moral values held by society, such as prohibitions on harming others. There is an overlap between immoral and illegal acts, as certain behaviors, such as theft or murder, are both morally wrong and prohibited by law. However, the difference between immoral and illegal acts is that some actions may be considered morally wrong without being legally prohibited, or illegal without being widely viewed as immoral. Legal theories. There are two main legal theories that underpin the law, which are legal positivism and natural law. The theory of legal positivism is that law derives its authority from formal sources such as Parliament, rather than from moral content. The theory of natural law is that law is based on inherent moral principles and that unjust laws lack true legal authority. Pluralism. A pluralist society is one where a range of different cultures, religions, values, and beliefs coexist within the same community. Pluralism is a key factor in shaping morality in society, as different groups bring their own moral values, influencing what is considered right and wrong. For example, moral views on issues such as same-sex relationships or euthanasia can vary significantly between cultural or religious groups. Moral views are diverse in a pluralist society as individuals are influenced by different traditions, experiences, and belief systems. For example, attitudes towards abortion or drug use may differ widely depending on personal, cultural, or religious perspectives. The relationship between law and morals. The relationship between law and morals is that law is often influenced by moral values, but it does not always reflect the full range of moral beliefs held in society. This relationship is important as it helps ensure that laws are seen as legitimate and acceptable by the public. However, this may not be important, as the law must remain clear, consistent, and enforceable even where moral views differ widely. An example of where morality and law have clashed in courts is Lee v. Asher's Baking Company Limited 1918, where religious beliefs conflicted with equality law over discrimination. Another example is DPP v. Ziegler 2021, where moral views on protest clashed with legal limits on public order and obstruction. Enforcement of morals. Moral values are enforced by law as the state translates widely accepted moral standards into legal rules that regulate behavior. This is done by Parliament passing legislation and courts applying and interpreting the law in specific cases. An example of moral values being enforced by law is DPP v. Ziegler 2021, where the Supreme Court balanced the moral importance of protest against the legal need to prevent obstruction of the highway. The Devlin-Hart debate. The Devlin-Hart debate is a legal debate about whether the law should enforce moral values or remain separate from morality. The main arguments in the Devlin-Hart debate are Devlin's view that law should enforce shared morality and Hart's view that law should protect individual freedom and less harm is caused to others. Devlin argues that society has the right to enforce common moral standards through law to preserve social cohesion, as shown in Lee v. Asher's Baking Company Limited 1918, where the court recognized the importance of protecting religious moral beliefs within the legal framework. Hart argues that the law should not enforce morality unless there is harm to others, as shown in DPP v. Ziegler 2021, where the court prioritized individual rights to protest over strict moral or public order objections. Evaluation of law and morality. The benefits of law and morality are that they promote social order, protect individual rights, and enhance the legitimacy of the legal system. Social order is a benefit as shared moral values reflected in law help regulate behavior and prevent harm, as shown in Patel v. Mirza 2016, where the Supreme Court relied on moral considerations to prevent enforcement of illegal contracts. Protection of individual rights is a benefit as moral principles guide the law to safeguard freedoms, as shown in DPP v. Ziegler 2021, where the court protected the moral importance of protest rights under the law. Legitimacy is a benefit as laws aligned with moral values are more likely to be respected and obeyed, as shown in Lee v. Asher's Baking Company Limited 2018, where the court balanced equality law with moral and religious beliefs. The drawbacks of law and morality are that they can conflict with pluralism, create legal uncertainty, and risk imposing majority morality on minorities. Conflict with pluralism is a drawback as enforcing a single moral view through law can marginalize minority beliefs, as shown in Lee v. Asher's Baking Company Limited 2018, where competing moral values led to social and legal tension. Legal uncertainty is a drawback as relying on moral judgment can make the law unpredictable, as shown in DPP v. Ziegler 2021, where differing views on morality and rights led to uncertainty over lawful protest. Imposing majority morality is a drawback as it can undermine individual autonomy and minority rights, as shown in Re Northern Ireland Human Rights Commission Abortion Case 2018, where strict moral views embedded in law conflicted with personal rights. Law and justice. Law is a system of rules created and enforced by the state that regulates behavior and resolves disputes within society. Whereas justice is the moral principle of fairness that aims to ensure people are treated equally and appropriately according to their actions and circumstances. Types of justice. The different types of justice within the law are distributive justice, procedural justice, and substantive justice. Distributive justice is concerned with the fair allocation of resources, rights, and punishments within society, as shown in R.V. Dudley and Stevens. Procedural justice focuses on fairness in the processes used to make legal decisions, as demonstrated in Intick v. Carrington. Substantive justice is about achieving fair and morally right outcomes through the law itself, as shown in R.V. Blau. Theories of justice. The theories of justice are natural law, legal positivism, and utilitarianism. Natural law theory argues that law should be based on moral principles that exist independently of human creation and are universal, meaning an unjust law is not a true law, as illustrated by the reasoning rejected in R.V. Dudley and Stevens. Legal positivism argues that law is valid if it is created by a recognized authority using accepted procedures, regardless of its moral content, meaning judges should apply the law as written, as demonstrated in R.V. Brown. Utilitarianism is based on the idea that laws should promote the greatest happiness for the greatest number of people, meaning individual rights may be limited to benefit society as a whole, as shown in R.V. Dudley and Stevens. Extent of justice. The law provides justice to a greater extent as it creates consistency and certainty through precedent, ensures fairness through established legal procedures, and protects individual rights against abuse of power. The law creates consistency and certainty through the doctrine of precedent, meaning similar cases are treated alike, which promotes fairness as shown in Donahue v. Stevenson. The law ensures fairness through established legal procedures such as the right to a fair trial, which promotes procedural justice as demonstrated in R.V. Ghosh. The law protects individual rights against abuse of power by limiting state authority, which ensures justice as shown in Intick v. Carrington. However, the law provides justice to a lesser extent as it can be rigid, may fail to consider moral fairness, and can be influenced by social and economic inequality. The law can be rigid because strict application of rules may lead to unjust outcomes, as shown in R.V. Blau where moral objections were not considered. The law may fail to consider moral fairness because judges are required to apply the law even if the outcome seems unjust, as demonstrated in R.V. Brown. The law can be influenced by social and economic inequality because access to justice often depends on financial resources, which can undermine fairness as illustrated in R.V. White. Evaluation of law and justice. The benefits of law and justice are the maintenance of social order, protection of individual rights, and promotion of fairness and equality. Law and justice maintain social order by setting clear standards of behavior and consequences for wrongdoing, which benefit society as shown in R.V. Church. Law and justice protect individual rights by holding others legally accountable for harm caused, as demonstrated in Donahue v. Stevenson. Law and justice promote fairness and equality by applying the same legal rules to everyone, which supports justice as shown in R.V. Smith. However, the drawbacks of law and justice are inflexibility, moral injustice in certain outcomes, and unequal access to legal remedies. Inflexibility is a drawback because strict legal rules can prevent judges from achieving fair outcomes in individual cases, as shown in R.V. Blau. Moral injustice is a drawback because the law may conflict with societal values, leading to outcomes that appear unfair, as demonstrated in R.V. Dudley and Stevens. Unequal access to legal remedies is a drawback because those with greater financial resources are often better able to pursue justice, which undermines equality as shown in R.V. White. Law and society. Law and society is the relationship between legal rules and social behavior, showing how law both reflects social values and influences how people act within a community. Role of law in society. The role that law has in society is to regulate behavior, resolve disputes, protect rights, and maintain social order by setting clear standards of acceptable conduct. Social control is the use of rules, norms, and sanctions to regulate individual and group behavior so that it conforms to societal expectations. Law can shape society through social control as it deters harmful behavior through punishment and encourages acceptable behavior through rewards and legal approval. Social control. The law is a social control mechanism, which means it formally controls behavior by enforcing rules backed by sanctions such as fines, imprisonment, or other legal consequences. The media can exaggerate or sensationalize certain behaviors, presenting them as a serious threat to society. This can lead to moral panic, where the public becomes fearful and demands action from lawmakers. As a result, new laws or harsher enforcement may be introduced to address the perceived problem, showing how media influences social change. Theories of social control. The theories behind law as a social control mechanism are functionalism, Marxism, and interactionism. Functionalism views law as a way to promote social stability and shared values by regulating behavior. Marxism sees law as a tool used by powerful groups to control and exploit less powerful groups. Interactionism focuses on how law labels individuals and how this labeling influences behavior. Law and society theories. The theories around law and society are consensus theory, conflict theory, and labeling theory. Consensus theory is the idea that laws are created based on shared values and agreement within society about what is right and wrong. It is reflected in the legal system as laws that protect widely accepted values such as prohibitions on murder and theft, which most members of society agree are wrong. Conflict theory is the view that law benefits powerful groups and is used to maintain their dominance over less powerful groups. It is reflected in the legal system as laws and enforcement practices that may disproportionately affect disadvantaged groups while protecting the interests of the wealthy or powerful. Labeling theory is the idea that individuals become deviant because they are labeled as such by society and authorities. It is reflected in the legal system as criminal records and court processes that can reinforce a deviant identity and increase the likelihood of reoffending. Realism. Realism is a theory that focuses on the practical causes of crime and how law should realistically respond to crime in society. The different viewpoints within realism are left realism and right realism. Left realism. Left realism is a theory that sees crime as caused by social inequality, deprivation, and relative disadvantage. Left realism has influenced laws and policies that focus on community policing and crime prevention. It has encouraged addressing social causes of crime such as poverty and lack of opportunity. This approach has also shaped victim-focused policies by recognizing the real harm crime causes to disadvantaged communities. Right realism. Right realism is a theory that views crime as a result of individual choice and lack of discipline. Right realism has led to tougher sentencing and greater emphasis on punishment as a deterrent. It supports policies such as zero-tolerance policing and longer prison sentences. This has influenced criminal law by prioritizing control and responsibility over rehabilitation. Evaluation of law and society. The benefits of law and society are the maintenance of social order, protection of individual rights, and promotion of fairness and equality. Maintaining social order is a benefit as law sets boundaries for behavior and consequences for wrongdoing, as shown in RV Church where unlawful conduct was clearly punished. Protecting individual rights is a benefit because the law holds others accountable for harm caused, as demonstrated in Donahue v. Stevenson where negligence law protected consumers. Promoting fairness and equality is a benefit as the law aims to treat individuals equally before the courts, as shown in RVR where marital rape was recognized as a crime. However, the drawbacks of law and society are inequality in enforcement, discrimination, and overcriminalization. Inequality in enforcement is a drawback as laws may be applied more harshly to certain groups, as seen in RV Grant where stop and search powers raised concerns about unfair targeting. Discrimination is a drawback because the legal system can reflect societal biases, as highlighted in RV Birmingham City Council where unequal treatment was challenged. Overcriminalization is a drawback as too many behaviors are controlled by law, limiting individual freedom, as shown in RV Brown where consensual acts were criminalized. Rules and theory of human rights law. Human rights law are principles designed to protect fundamental rights and freedoms that belong to every person simply because they are human. Rules of human rights law. The rules of human rights law are universality, interdependence, inalienable rights, indivisible rights, dignity, pluralism, and the approaches to interpretation. Universality is the principle that human rights apply to all individuals without discrimination, regardless of nationality, status, or background. It reflects the idea that rights are inherent to humanity rather than granted by the state. As a result, states are expected to respect and protect the rights of everyone within their jurisdiction. Interdependence is the principle that all human rights are connected and mutually reinforcing. The enjoyment of one right often depends upon the fulfillment of others, such as the link between education and freedom of expression. This means that rights cannot be fully realized in isolation from one another. Inalienable rights are rights that cannot be taken away or surrendered, except in limited and lawful circumstances. They are inherent to each person and do not depend upon government recognition for their existence. Even where certain rights may be restricted, their core essence remains protected. Indivisible rights are the principle that all human rights have equal status and importance. Civil and political rights cannot be prioritized over economic, social, and cultural rights, nor vice versa. This ensures that the protection of one category of rights does not undermine another. Dignity is the foundational value where all human rights are based, recognizing the intrinsic worth of every individual. It requires that individuals are treated with respect and not subjected to degrading treatment. Many specific rights derive their meaning and scope from the protection of human dignity. Pluralism is the recognition that democratic societies are composed of diverse beliefs, cultures, and ways of life. Human rights law protects this diversity by safeguarding freedoms such as expression, religion, and association. It ensures that minority views are respected equally alongside majority perspectives. The approaches to interpretation are balancing of rights, proportionality, and the margin of appreciation. Balancing of rights is an approach where courts weigh competing rights or interests against each other to determine which is more important in the specific circumstances of a case. Proportionality is an approach where any restriction on a right must have a legitimate aim, be suitable and necessary to achieve that aim, and strike a fair balance between individual rights and the interests of the community. The margin of appreciation is an approach where national authorities are given a degree of discretion in how they implement and apply human rights standards, particularly where there is no clear consensus among states or where cultural and social contexts differ. Theories of human rights law. The theories of human rights law are the rule of law, democracy, and the separation of powers. The rule of law is the principle that all individuals and public authorities are subject to and accountable under the law. It requires that laws are clear, accessible, and applied equally, ensuring legal certainty and fairness. Within human rights law, the rule of law safeguards individuals from arbitrary power and provides mechanisms where rights can be enforced through independent courts. Democracy is the theory that legitimate government authority derives from the will and participation of the people. It promotes political equality, accountability, and regular elections, allowing citizens to influence decision-making. In human rights law, democracy both depends upon and reinforces rights such as freedom of expression, association, and participation in public life. The separation of powers is the theory that governmental power should be divided between the legislature, the executive, and the judiciary. This division prevents the concentration of power and creates checks and balances between institutions. In the context of human rights law, the separation of powers ensures that courts can independently review the actions of the other branches to protect individual rights. Protection of the individual's human rights and freedoms in the UK. The individual's rights are protected in the UK by the Human Rights Act 1998, common law, and international human rights agreements. The individual's freedoms are protected in the UK by statutes passed by Parliament, judicial decisions developed through common law, and the incorporation of the European Convention of Human Rights into domestic law. A history of the ECHR and ECTHR. The European Convention of Human Rights and the European Court of Human Rights were both established by the Council of Europe to ensure the protection of rights across Europe. European Convention of Human Rights. The European Convention of Human Rights is an international treaty created by the Council of Europe that sets out fundamental rights and freedoms that member states must respect. The Second World War led to the creation of the European Convention of Human Rights because the widespread atrocities and abuse of power committed during the Second World War highlighted the need for stronger protection of individual rights across Europe. After the war, European states wanted to prevent similar abuses from occurring again by creating a shared system of human rights protection. This led to the establishment of the Council of Europe in 1949 to promote democracy, the rule of law, and human rights. The Council of Europe then drafted the European Convention of Human Rights in 1950 to formally protect fundamental rights across its member states. European Court of Human Rights. The European Court of Human Rights is an international court based in Strasbourg where cases are heard about alleged violations of rights contained in the European Convention of Human Rights. The European Court of Human Rights was established in 1959 by the Council of Europe to ensure that member states complied with the European Convention of Human Rights. Initially, individuals could not apply directly to the court, and applications first had to go through the European Commission of Human Rights. In 1998, the system was reformed by Protocol 11 to the European Convention of Human Rights, where the Commission was abolished and individuals were given the right to apply directly to the court. Since then, the court has become a permanent international court where it hears cases brought by individuals and states who claim that rights under the convention have been violated. Human Rights Act. The Human Rights Act 1998 is a UK statute where rights contained in the European Convention of Human Rights are incorporated into domestic law so that they can be enforced in UK courts. The main sections of the Human Rights Act 1998 are Sections 2, 3, 4, and 6. Section 2 of the Human Rights Act 1998 forces UK courts must take into account decisions of the European Court of Human Rights when determining questions related to convention rights. The impact of Section 2 on domestic law is that UK judges consider relevant case law from the Strasbourg Court when interpreting human rights issues. Section 3 of the Human Rights Act 1998 states that legislation must be interpreted in a way where it is compatible with convention rights, as closely as possible. The impact of Section 3 on domestic law is that courts can interpret legislation so that it is compatible with convention rights without having to invalidate acts of Parliament. Section 4 of the Human Rights Act 1998 states that higher courts may issue a declaration of incompatibility if legislation cannot be interpreted in a way that is consistent with convention rights. The impact of Section 4 on domestic law is that the legislation remains valid, but Parliament is formally notified that the law is incompatible with human rights. Section 6 of the Human Rights Act 1998 states that it is unlawful for public authorities to act in a way that is incompatible with convention rights unless required by primary legislation. The impact of Section 6 on domestic law is that individuals may challenge the actions of public authorities in UK courts if they have breached convention rights. The nature of the Human Rights Act in devolution. Devolution is the transfer of certain powers from the UK Parliament to regional legislatures and governments within the UK. The nature of the Human Rights Act 1998 in Scotland is that the Scotland Act 1998 prevents the Scottish Parliament from passing legislation that is incompatible with convention rights. The nature of the Human Rights Act 1998 in Wales is that the Government of Wales Act 2006 requires the Welsh Government and Senate to act in a way that is compatible with convention rights. The nature of the Human Rights Act 1998 in Northern Ireland is that the Northern Ireland Act 1998 prevents the Northern Ireland Assembly from legislating in a way that breaches convention rights. Overall, devolution settlements guarantees that human rights are respected as devolved legislatures and governments must act in a way that complies with the European Convention on Human Rights. The European Convention on Human Rights. The European Convention on Human Rights is an international agreement created by the Council of Europe to protect fundamental human rights and freedoms across its member states. The key provisions of the European Convention on Human Rights are a set of legal rights and freedoms that governments must respect and protect for everyone within their jurisdiction. The main articles in the Convention are Articles 5, 6, 8, 10, and 11. Article 5. Article 5 provides the right to liberty and security of the person, protecting individuals from unlawful or arbitrary detention by the state. This means that a person cannot be deprived of their freedom unless it is done lawfully and according to proper legal procedures. The key terms in Article 5 are liberty, security, lawful arrest, and reasonable suspicion. Liberty is the freedom of a person to move and live without unjustified interference or detention by the authorities. Security is the protection of a person from unlawful detention and the assurance that their freedom will not be taken away without legal justification. Lawful arrest is the detention of a person carried out according to the law and proper legal procedures. Reasonable suspicion is the belief that a person may have committed a crime based on objective facts, providing legal justification for arrest. Article 6. Article 6 provides the right to a fair trial for anyone involved in criminal or civil proceedings. This means that a person must be given a fair and public hearing by an independent and impartial tribunal established by law. The key terms in Article 6 are fair trial, independent tribunal, impartial tribunal, and public hearing. A fair trial means that legal proceedings are conducted justly, where both sides are able to present their case and the decision is based on the evidence. An independent tribunal is a court or body that is free from influence or control by the government or other external pressures. An impartial tribunal is a court or judge that does not favor either side and makes decisions without bias. A public hearing means that court proceedings are normally open to the public and the press so that justice is transparent. Article 8. Article 8 provides the right to respect for private and family life, home, and correspondence. This means that individuals have the right to live their personal and family lives without unnecessary interference from the state. The key terms in Article 8 are private life, family life, home, and correspondence. Private life is a person's right to personal privacy, including their identity, personal relationships, and personal activities. Family life is the right of individuals to maintain relationships with their family members without unjustified interference. Home is a place where a person lives and has the right to enjoy privacy and protection from unlawful intrusion. Correspondence is communication, such as letters, phone calls, or electronic messages that should remain private and protected from interference. Article 10. Article 10 provides the right to freedom of expression, allowing individuals to express their opinions and share information and ideas without unjustified interference by the state. This means that people are free to communicate their views and receive information through speech, writing, media, or other forms of communication. The key terms in Article 10 are freedom of expression, opinions, information, and interference. Freedom of expression is the right of individuals to express ideas, beliefs, and opinions without unjustified restrictions. Opinions are personal beliefs or viewpoints that individuals are free to hold and communicate. Information is facts, news, or knowledge that people have the right to receive and share with others. Interference means actions by authorities that restrict or limit a person's ability to express or communicate ideas. Article 11. Article 11 provides freedom of assembly and association, allowing individuals to gather peacefully and join groups or organizations. This means that people have the right to meet together, protest peacefully, and form or join organizations such as trade unions. The key terms in Article 11 are assembly, association, peaceful protest, and trade union. Assembly is the right of people to gather together in groups for meetings, demonstrations, or protests. Association is the right of individuals to join or form groups, organizations, or societies for a shared purpose. Peaceful protest is a demonstration where people express their views publicly without violence or disorder. Trade unions are organizations formed by workers to represent and protect their interests in the workplace. Restrictions. The restrictions that are permitted by the European Convention on Human Rights are limits placed on certain rights where they are necessary to protect the rights of others, maintain public safety, and uphold the interests of society. Restrictions from the ECHR. National security is a restriction where rights may be limited to protect the safety and stability of the state from serious threats. Public safety is a restriction where certain rights may be limited to protect people from danger or serious harm. The prevention of disorder or crime is a restriction where rights may be limited to maintain law and order and prevent criminal activity. The protection of health is a restriction where rights may be limited to protect the physical and mental well-being of the public. The protection of morals is a restriction where rights may be limited to maintain accepted standards of behavior within society. The protection of the rights and freedoms of others is a restriction where a person's rights may be limited to ensure that other people's rights are equally protected. The prevention of the disclosure of information received in confidence is a restriction where rights may be limited to protect confidential information from being revealed. Maintaining the authority and impartiality of the judiciary is a restriction where rights may be limited to protect the fairness and independence of the courts. Restrictions from domestic law. Proportionality is a restriction where any limitation on a right must be balanced and not excessive compared with the aim it is trying to achieve, and this principle comes from the Human Rights Act 1998. Police stop and search is a restriction where a person may be temporarily detained and searched in order to prevent crime or find prohibited items, and this restriction comes from the Police and Criminal Evidence Act 1984. Detention after arrest is a restriction where a person's liberty may be limited while the police investigate a suspected offense, and this restriction comes from the Police and Criminal Evidence Act 1984. Control of public protests is a restriction where authorities may place conditions on demonstrations to prevent disorder or disruption, and this restriction comes from the Public Order Act 1986. Restrictions on freedom of expression is a restriction where speech may be limited if it encourages hatred or discrimination against others, and this restriction comes from the Public Order Act 1986. Human rights and English law. Human rights are fundamental rights and freedoms that belong to every individual and are protected to ensure dignity, liberty, fairness, and respect within society. The human rights that are protected by English law are reflected in areas such as public order offences, police powers, interception of communications, the duty of confidentiality, obscenity, the torts of defamation and trespass, and harassment. Public order offences. A public order offence is a criminal offence where behaviour threatens, disrupts, or harms the peace and safety of the public and therefore justifies legal restrictions on certain individual freedoms. Article 10 of the European Convention on Human Rights protects the right to freedom of expression, including the freedom to hold opinions and to receive and share information and ideas without interference from public authorities. Article 11 of the European Convention on Human Rights protects the right to freedom of peaceful assembly and association with others. The different types of public order offences are breach of the peace, criminal offences under the Public Order Act 1986 of riot, violent disorder, and affray, and illegal forms of assembly. Breach of the peace. Breach of the peace is a common law offence where a person causes harm, threatens harm, or acts in a way that is likely to cause violence or disturbance to others. Breach of the peace restricts Article 10 as the police may intervene to prevent speech or behaviour likely to provoke violence, as shown in Redmond Bate v. Director of Public Prosecutions. Breach of the peace restricts Article 11 as assemblies may be stopped or individuals may be removed where violence is likely to occur, as shown in Laporte v. Chief Constable of Gloucestershire. Public Order Act. Riot, violent disorder, and affray under the Public Order Act 1986 are criminal offences where individuals use or threaten unlawful violence, with riot involving 12 or more people, violent disorder involving 3 or more people, and affray involving 1 or more individuals, causing fear for personal safety. These offences restrict Article 10 as expression that involves threats or violence can be limited by the state, as shown in Director of Public Prosecutions v. Ziegler. These offences restrict Article 11 as gatherings that involve or threaten violence may be restricted or prosecuted to protect public safety, as shown in R. v. Howell. Illegal assembly. Illegal forms of assembly occur where a gathering or protest fails to comply with legal requirements or becomes unlawful due to disorder, violence, or failure to follow police directions. Illegal forms of assembly restrict Article 10 as the state may limit the way where individuals express views during protests where public order is threatened, as demonstrated in Director of Public Prosecutions v. Jones. Illegal forms of assembly restrict Article 11 as the law allows authorities to regulate or remove assemblies that are no longer peaceful or lawful, as shown in Austin v. Commissioner of Police of the Metropolis. Police powers. Police powers are the legal authorities given to the police by statute and common law to prevent crime, investigate offences, and maintain public order while balancing the protection of individual rights. Article 5 of the European Convention on Human Rights protects the right to liberty and security of the person and states that no one should be deprived of their liberty unless lawful procedure is followed. Article 6 of the European Convention on Human Rights protects the right to a fair trial, including the right to be presumed innocent, to have legal representation, and to have a fair and public hearing. Under the Police and Criminal Evidence Act 1984, police have the power to stop and search individuals and to arrest and detain suspects. Stop and search. Stop and search is a police power that allows officers to search a person or vehicle where they have a reasonable suspicion that stolen or prohibited items may be found. Stop and search restricts Article 5 as it temporarily interferes with a person's liberty while they are detained for the search, as illustrated in Gillen v. United Kingdom. Stop and search restricts Article 6 as the use of suspicion-based searches can raise concerns about fairness and justification in criminal proceedings, as shown in Castorina v. Chief Constable of Surrey. Arrest and detention. Arrest and detention is a police power that allows officers to take a suspect into custody if it is necessary and as long as there are reasonable grounds to believe that the person has committed or is about to commit an offense. Arrest and detention restricts Article 5 as it involves the lawful deprivation of liberty where a person is held in custody, as demonstrated in Fox, Campbell and Hartley v. United Kingdom. Arrest and detention restricts Article 6 as the treatment of suspects during detention can affect their ability to receive a fair trial, as shown in Murray v. United Kingdom. Police and Criminal Evidence Act. The Police and Criminal Evidence Act 1984 sets out the procedures that police must follow to ensure individuals' rights are respected, which are the right to legal advice, the right to have someone informed of the arrest, and the requirement to follow codes of practice. The right to legal advice is a safeguard where a detained suspect must be allowed to consult a solicitor privately, and this respects Article 5 and Article 6 as it protects the detainee's liberty and ensures a fair legal process, as shown in R. v. Samuel. The right to have someone informed of the arrest is a safeguard where a detainee can request that a friend or relative is notified of their detention, and this respects Article 5 and Article 6 as it prevents unlawful detention and supports fairness in the legal process, as demonstrated in R. v. Hookway. The requirement to follow codes of practice is a safeguard where police must follow detailed rules governing detention, questioning, and the treatment of suspects, and this respects Article 5 and Article 6 as it ensures lawful detention and fairness in criminal proceedings, as shown in R. v. Aspinall. Interception of communications. Interception of communications is the monitoring, accessing, or recording of private communication such as telephone calls, emails, and messages by public authorities. Article 8 of the European Convention on Human Rights is the right to respect for private and family life, home, and correspondence. Regulation of Investigatory Powers Act. The Regulation of Investigatory Powers Act 2000 allows the government to authorize the interception of communications and the use of surveillance where it is necessary for national security, preventing crime, or protecting public safety. This means that public authorities may legally monitor or obtain private communications as long as it has been authorized, which restricts Article 8 as it interferes with an individual's right to privacy, as shown in Malone v. United Kingdom. Investigatory Powers Act. The Investigatory Powers Act 2016 allows the government to collect, retain, and access large amounts of communications data, including internet and telephone records, through warrants authorized by senior officials and approved by judicial commissioners. This means that authorities can carry out bulk surveillance and require communication companies to retain user data, which restricts Article 8 as it interferes with private communications and personal data, as demonstrated in Big Brother Watch v. United Kingdom. Duty of confidentiality. The duty of confidentiality is a legal obligation that requires individuals who receive private or sensitive information to keep it secret and not disclose it without permission or lawful justification. Article 8 of the European Convention on Human Rights is the right to respect for private and family life, home, and correspondence. Article 10 of the European Convention on Human Rights is the right to freedom of expression, including the freedom to hold opinions and to receive and impart information and ideas. The duty of confidentiality respects Article 8 as it protects private information from being disclosed without consent, for example in Campbell v. Mirror Group newspapers. The duty of confidentiality respects Article 10 as it recognizes that freedom of expression may justify the publication of certain information where there is a public interest, for example in Attorney General v. Guardian Newspapers Limited. The duty of confidentiality balances the two articles by requiring courts to weigh the importance of privacy against the importance of freedom of expression before deciding whether information should be disclosed, for example in Re S.A. Child. Obscenity. Obscenity is the publication or distribution of material that is considered morally offensive or likely to deprave and corrupt those who view, read, or hear it. Article 10 of the European Convention on Human Rights is the right to freedom of expression, including the freedom to hold opinions and to receive and impart information and ideas without interference from public authorities. Obscenity restricts Article 10 as the law limits the publication and distribution of obscene material in order to protect public morals and prevent harm, for example in R.V. Hicklin. The torts of defamation and trespass. Defamation is a civil wrong where a false statement is communicated to a third party and harms the reputation of another person. The torts of defamation are libel and slander. Libel is defamation in permanent form such as writing or broadcasting, whereas slander is defamation in temporary form such as spoken words. Article 10 of the European Convention on Human Rights is the right to freedom of expression, including the freedom to hold opinions and to receive and impart information and ideas. The torts of defamation restrict Article 10 as the law limits what individuals can publish or say about others in order to protect reputation, for example in Reynolds v. Times Newspapers Limited. Trespass is a civil wrong where a person intentionally enters or interferes with another person's land, goods, or body without lawful justification. The torts of trespass are trespass to the person, trespass to land, and trespass to goods. Article 11 of the European Convention on Human Rights is the right to freedom of peaceful assembly and association with others. The torts of trespass restrict Article 11 as individuals who enter private land to take part in protests or gatherings without permission may be liable for trespass, for example in Appleby v. United Kingdom. Harassment. Harassment is behavior where a person repeatedly causes alarm, distress, or intimidation to another person through actions such as threats, abuse, or unwanted contact. Article 10 of the European Convention on Human Rights is the right to freedom of expression, including the freedom to hold opinions and to receive and impart information and ideas. Harassment restricts Article 10 as the law limits certain forms of speech or communication where they cause serious distress or intimidation to others. The laws on harassment respect Article 10 as courts must consider whether restrictions on speech are necessary and proportionate when protecting victims from harassment, for example in Madrowski v. Guys and St. Thomas NHS Trust. Enforcement of human rights law. Human rights law is enforced by domestic courts by interpreting and applying legislation, as well as through judicial review and access to the European Court of Human Rights. Role of domestic courts. Domestic courts are national courts within the UK where legal disputes are resolved and where human rights are interpreted and enforced. Interpreting and applying human rights. Domestic courts play a crucial role in interpreting human rights law by using Section 3 of the Human Rights Act 1998 to read legislation in a way that is compatible with rights provided by the European Convention of Human Rights, as seen in Gaydon v. Godin-Mendoza. Domestic courts also consider decisions from the European Court on Human Rights when interpreting legislation to ensure consistency with Convention principles. Domestic courts therefore ensure that legislation is understood in a way that upholds individual rights wherever possible. Domestic courts play a key role in applying human rights law by directly applying Convention rights in cases brought before them under the Human Rights Act 1998, as demonstrated in RVA. Domestic courts assess whether public authorities have acted in a way that is compatible with human rights and can provide remedies where breaches occur. Domestic courts therefore ensure that individuals can rely on their rights in real legal disputes. Enforcing human rights. The mechanisms within domestic courts for enforcing human rights before the year 2000 were limited to indirect methods such as common law and statutory interpretation. The common law mechanism involved judges developing legal principles that protected fundamental rights. This helped enforce human rights law by allowing courts to protect liberties, as shown in Intick v. Carrington. The statutory interpretation mechanism involved courts interpreting legislation in line with fundamental rights where possible. This helped enforce human rights law by enabling courts to avoid interpretations that infringed rights, as seen in RV Secretary of State for the Home Department ex parte Sims. The mechanisms within domestic courts for enforcing human rights after the year 2000 were expanded under the Human Rights Act 1998 to include Section 3 interpretation, Section 4 declarations of incompatibility, and Section 6 duties on public authorities. The Section 3 interpretation mechanism requires courts to interpret legislation as closely as possible to the European Convention on Human Rights. This helped enforce human rights law by allowing courts to uphold rights without overturning legislation, as shown in Gaydon v. Godin-Mendoza. The Section 4 declaration of incompatibility mechanism allows courts to declare that legislation is incompatible with the European Convention on Human Rights. This helped enforce human rights law by prompting Parliament to amend legislation, as demonstrated in Bellinger v. Bellinger. The Section 6 mechanism makes it unlawful for public authorities to act in a way that is incompatible with the European Convention on Human Rights. This helped enforce human rights law by allowing individuals to challenge unlawful actions, as seen in Aston Cantlow v. Wallbank. Judicial review. Judicial review is the process where the courts supervise the actions of public authorities to ensure that they act lawfully and in accordance with human rights. Judicial review enforces human rights by allowing individuals to challenge decisions of public authorities that go against the European Convention on Human Rights, which is allowed by the Human Rights Act 1998, as seen in R.V. Secretary of State for the Home Department ex parte Daily. Judicial review also involves the courts assessing whether a public authority has acted unlawfully, irrationally, or disproportionately in breaching human rights. Judicial review therefore provides an effective domestic remedy by enabling courts to uphold rights and hold public bodies accountable. The European Court of Human Rights. The European Court of Human Rights is an international court based in Strasbourg that hears cases concerning alleged breaches of the European Convention on Human Rights by member states. Bringing a case to the court. The procedure for bringing a case before the European Court of Human Rights involves an individual first being dissatisfied with all domestic remedies within their national courts before submitting an application to the court in Strasbourg, where the application is assessed for admissibility against strict criteria. The criteria for admission for a case to the court is that the applicant must be a victim of a violation, must have exhausted all domestic remedies, must apply within the required time limit, and must present a claim that has some merit to it. The procedure then requires the court to consider written submissions from both parties and, in some cases, hold a hearing before reaching a judgment on whether there has been a breach of the European Convention on Human Rights. The procedure concludes with a binding judgment, where the court may award just satisfaction and require the state to take steps to remedy the violation. The court's guiding principles. The guiding principles of the European Court of Human Rights include subsidiarity, meaning that national courts have the primary responsibility for protecting rights under the European Convention on Human Rights. The guiding principles also include the margin of appreciation, where states are given some discretion in how they apply rights depending on their legal and cultural context. The guiding principles further include the idea that rights must be practical and effective, ensuring that individuals can genuinely exercise their rights in real situations. Evaluation of human rights law. The benefits of human rights law are that it protects fundamental freedoms, promotes fairness, and provides remedies against abuse of power, whereas the drawbacks are that it can limit parliamentary sovereignty, involve unelected judges in decision-making, and be applied inconsistently. European Convention on Human Rights. The European Convention on Human Rights is an international treaty that protects fundamental rights and freedoms across member states of the Council of Europe. Article 5. Article 5 of the ECHR is the right to liberty and security of the person. The protections of Article 5 are that individuals cannot be deprived of liberty without lawful justification, whereas the restrictions of Article 5 are that detention is permitted in limited circumstances such as lawful arrest or mental health detention. The benefits of Article 5 are protection against arbitrary detention, promotion of legal certainty, and safeguarding individual liberty. The protection against arbitrary detention is a benefit as it prevents unlawful imprisonment by the state, as shown in Intick v. Carrington. The promotion of legal certainty is a benefit as it ensures clear legal procedures are followed before detention, as shown in Steele v. United Kingdom. The safeguarding of individual liberty is a benefit as it upholds freedom from unjust state control, as shown in A.V. Secretary of State for the Home Department. However, the drawbacks of Article 5 are that it allows exceptions for detention, can conflict with public safety, and may be interpreted inconsistently. The allowance of exceptions for detention is a drawback as individuals can still be lawfully detained in broad circumstances, as shown in Brogan v. United Kingdom. The conflict with public safety is a drawback as protecting liberty may limit the state's ability to prevent threats, as shown in A.V. Secretary of State for the Home Department. The potential for inconsistent interpretation is a drawback as different courts may apply the rules differently, as shown in Austin v. Commissioner of Police of the Metropolis. Article 6. Article 6 of the ECHR is the right to a fair trial. The protections of Article 6 are that individuals are entitled to a fair and public hearing by an independent tribunal, whereas the restrictions of Article 6 are that certain limitations may apply in the interests of justice, such as confidentiality. The benefits of Article 6 are fairness in legal proceedings, protection against bias, and the right to legal representation. Fairness in legal proceedings is a benefit as it ensures both sides are heard equally, as shown in R.V. Secretary of State for the Home Department ex parte Anderson. Protection against bias is a benefit as it requires an independent and impartial tribunal, as shown in Porter v. McGill. The right to legal representation is a benefit as it allows individuals to defend themselves effectively, as shown in A v. Ireland. However, the drawbacks of Article 6 are that trials can become lengthy, it can be costly to enforce, and some limitations may still restrict fairness. The length of trials is a drawback as ensuring full fairness can delay justice, as shown in Barker v. Wingo. The cost of enforcement is a drawback as accessing fair trial rights may require significant legal resources, as shown in A v. Ireland. The existence of limitations is a drawback as some hearings may be restricted for security reasons, as shown in RVH. Article 8. Article 8 of the ECHR is the right to respect for private and family life. The protections of Article 8 are that individuals have privacy and family life respected, whereas the restrictions of Article 8 are that interference is allowed if it necessary, such as for national security or crime prevention. The benefits of Article 8 are protection of privacy, recognition of family relationships, and control over personal information. Protection of privacy is a benefit as it prevents unjustified intrusion by the state or others, as shown in Campbell v. MGN Limited. Recognition of family relationships is a benefit as it protects the right to maintain family life, as shown in Re G. Control over personal information is a benefit as it allows individuals to manage how their data is used, as shown in S and Marper v. United Kingdom. However, the drawbacks of Article 8 are that it can conflict with other rights, is broadly interpreted, and allows justified interference. Conflict with other rights is a drawback as privacy may clash with freedom of expression, as shown in Campbell v. MGN Limited. Broad interpretation is a drawback as the wide scope can create uncertainty, as shown in Pretty v. United Kingdom. The allowance of justified interference is a drawback as the state can override privacy rights, as shown in S and Marper v. United Kingdom. Article 10. Article 10 of the ECHR is the right to freedom of expression. The protections of Article 10 are that individuals can express opinions and share information, whereas the restrictions of Article 10 are that expression may be limited, such as for public safety or protecting others' rights. The benefits of Article 10 are promotion of democracy, encouragement of free speech, and protection of the press. Promotion of democracy is a benefit as open expression allows political debate, as shown in Handicide v. United Kingdom. Encouragement of free speech is a benefit as individuals can share ideas without fear, as shown in Lingens v. Austria. Protection of the press is a benefit as journalists can report on matters of public interest, as shown in Sunday Times v. United Kingdom. However, the drawbacks of Article 10 are that it can enable harmful speech, requires balancing with other rights, and includes broad restrictions. The enabling of harmful speech is a drawback as offensive or dangerous ideas may still be expressed, as shown in Handicide v. United Kingdom. The need for balancing is a drawback as courts must weigh expression against other rights, as shown in Campbell v. MGN Limited. The existence of broad restrictions is a drawback as the state can limit expression in many situations, as shown in Sunday Times v. United Kingdom. Article 11. Article 11 of the ECHR is the right to freedom of assembly and association. The protections of Article 11 are that individuals can gather and form associations, whereas the restrictions of Article 11 are that these rights may be limited for public safety or prevention of disorder. The benefits of Article 11 are protection of protest rights, support for trade unions, and promotion of collective action. Protection of protest rights is a benefit as individuals can demonstrate their views publicly, as shown in Platform Arstifer das Leben v. Austria. Support for trade unions is a benefit as workers can organize collectively, as shown in Wilson v. United Kingdom. Promotion of collective action is a benefit as groups can pursue shared interests, as shown in Redfern v. United Kingdom. However, the drawbacks of Article 11 are that protests can be restricted, public order concerns may override rights, and the scope can be limited. Restrictions on protests are a drawback as authorities can limit demonstrations, as shown in Austin v. Commissioner of Police of the Metropolis. Public order concerns are a drawback as safety may take priority over assembly rights, as shown in Platform Arstifer das Leben v. Austria. The limited scope is a drawback as not all forms of association are fully protected, as shown in Redfern v. United Kingdom. English law. The protections on human rights offered by English law are derived from common law rights such as liberty and privacy, judicial precedent, and statutes such as the Equality Act 2010. Whereas the restrictions are that Parliament can override rights through legislation, rights are not codified in a single document, and judicial protection depends on interpretation. The benefits of English law in regards to human rights are flexibility, strong precedent-based development, and democratic legitimacy. Flexibility is a benefit as judges can adapt legal principles to reflect modern values and circumstances, as shown in our VR. Strong precedent-based development is a benefit as courts can gradually expand rights through case law, as shown in Intick v. Carrington. Democratic legitimacy is a benefit as Parliament retains ultimate authority over rights, ensuring that laws reflect the will of the people, as shown in Jackson v. Attorney General. However, the drawbacks are lack of clarity, limited accessibility, and inconsistency. Lack of clarity is a drawback as rights are scattered across cases and statutes rather than clearly set out, as shown in Malone v. Metropolitan Police Commissioner. Limited accessibility is a drawback as individuals may struggle to understand or enforce their rights without legal knowledge, as shown in Wainwright v. Home Office. Inconsistency is a drawback as judicial decisions can vary and lead to uncertainty, as shown in Hill v. Chief Constable of West Yorkshire. The Human Rights Act. The Human Rights Act incorporates the European Convention on Human Rights into UK law and requires public authorities to act compatibly with convention rights. The benefits of the Human Rights Act are greater accessibility of rights, stronger judicial protection, and effective remedies. Greater accessibility of rights is a benefit as individuals can enforce their rights in domestic courts rather than going to Strasbourg, as shown in our v. Secretary of State for the Home Department ex parte Daily. Stronger judicial protection is a benefit as courts must interpret legislation in a way that is compatible with rights where possible, as shown in Gaydon v. Godin Mendoza. Effective remedies is a benefit as courts can provide relief where rights are breached, as shown in Campbell v. MGN Limited. However, the drawbacks are judicial overreach, uncertainty in interpretation, and limited power over Parliament. Judicial overreach is a drawback as judges may effectively change the meaning of legislation through interpretation, as shown in Gaydon v. Godin Mendoza. Uncertainty in interpretation is a drawback as the requirement to interpret legislation compatibly can lead to unpredictable outcomes, as shown in RVA. A limited power over Parliament is a drawback as courts cannot strike down primary legislation and can only issue declarations of incompatibility, as shown in Bellinger v. Bellinger. Ideas for reform. Human rights law should be reformed as it can lack clarity, create judicial overreach, and fail to balance rights with public interests effectively. The lack of clarity is a reason for reform as the broad wording of rights can lead to uncertainty and inconsistent interpretation by courts. Judicial overreach is a reason for reform as unelected judges may effectively shape policy through interpretation rather than leaving decisions to Parliament. The failure to balance rights with public interests is a reason for reform as rights may sometimes override concerns such as national security or crime prevention. However, human rights should not be reformed as they provide essential protections, promote accountability, and uphold the rule of law. The provision of essential protections is a reason against reform as human rights safeguard individuals from abuse by the state. The promotion of accountability is a reason against reform as public authorities can be challenged where they act unlawfully. The upholding of the rule of law is a reason against reform as human rights ensure that laws are applied fairly and consistently. The potential ideas for reform of human rights law include clarifying the wording of rights, limiting judicial interpretation, and increasing the role of Parliament. Clarifying the wording of rights is a reform that would involve making legal provisions more precise to reduce ambiguity. This reform would benefit the legal system as it would improve consistency and predictability in court decisions. This reform would have drawbacks as overly specific wording could reduce flexibility and limit the ability to adapt to new situations. Limiting judicial interpretation is a reform that would involve restricting how far courts can go in interpreting legislation. This reform would benefit the legal system as it would reinforce parliamentary sovereignty and democratic decision-making. This reform would have drawbacks as it could weaken the protection of individual rights where courts are unable to act effectively. Increasing the role of Parliament is a reform that would involve giving elected representatives greater control over defining and applying rights. This reform would benefit the legal system as it enhances democratic legitimacy and accountability. This reform would have drawbacks as Parliament may prioritise political interests over the protection of minority rights. UK Bill of Rights. Another proposed reform is the UK Bill of Rights, which is a proposed piece of legislation intended to replace or reform the Human Rights Act and redefine how rights are protected in the UK. The benefits of introducing the UK Bill of Rights are increased national control, clearer rights framework, and reinforcement of parliamentary sovereignty. Increased national control is a benefit as it allows the UK to interpret and apply rights without reliance on external courts. A clearer rights framework is a benefit as it could make rights more accessible and easier to understand. Reinforcement of parliamentary sovereignty is a benefit as it ensures that elected lawmakers have the final say on rights issues. However, the drawbacks are reduced protection of rights, risk of political influence, and potential conflict with international obligations. Reduced protection of rights is a drawback as removing established safeguards may weaken individual protections. Risk of political influence is a drawback as rights could be shaped by changing governments rather than stable legal principles. Potential conflict with international obligations is a drawback as divergence from existing frameworks may create legal uncertainty and disputes with other states. Thank you for watching this video on the nature of law and human rights law. I'll see you in the next one.